Uh, May I have the Lordship? Yes, Lordship, I may be allowed kindly to move a AB, my lord, urgently, my lord, unlisted at 2 tomorrow. My only urgency is that 41 in notice was given. Today is the date. 41 in notice was given. Today is the date to comply.
Summoning you to appear.
Appear today, my lords. Okay, tomorrow.
Today, tomorrow.
May I please, Lordship? Lordship, in item number 4 and 5, in item number 5, I have already filed my wakalat number. In item number 4, I'm yet to file.
Yes.
So I may be allowed 2 weeks time.
On the prayer, Mr. K. Lodin constituted respondent.
Yes, Lord. Yes, Lord.
Respondent number?
We have Lordship, respondent number 2
Respondent
in item 4 and in item 5 also for
list this matter after
2 weeks.
2 weeks.
Deeply obliged.
Your Lordship, may I please? I would like to mention item number 8, Your Lordship.
8.
Yes, sir. This is a criminal petition. This may be posted for tomorrow, Your Lordship. This leading counsel having some troubility at this place, Your Lordship, station out of.
Next week.
Kindly for tomorrow, Lordship.
Or other than this match.
Okay.
376.
Yes. Yesterday 76.
376.
Yes, Your Lordship. Then maybe of 1 week. Okay. Yes. Much of.
No. I'm not forcing you. You just decide.
Okay, after 3 weeks, it may be posted after 3 weeks, or say.
Let's see next week.
Okay. Much
We are
obliged.
praying for tomorrow.
Yes, I'm praying for tomorrow, or say.
Next week, we'll see next week. You take a call.
Okay, much obliged. Sir.
But maybe this week.
That's yours.
You
Much
decide.
of. Yes.
On the Mr. Sway's counsel for the petitioner.
Your Lordship, I beg to mention item number.
Just wait. What's your name? The item 8. On the prayer of loving counsel, on the prayer of Mr. Bita, loving counsel of the petitioner. This matter. Next week, when? Just say next week. We'll see. Pray that it may not be listed. Next.
I beg to mention item number 26, Your Honor.
Yes.
We are for the petitioner here. That the leading counsel is out of station due to some medical circumstances, Your Lordship. So matter may be
Who? You are for?
V Jamo Dike Thongdok.
Respondent.
Petitioner here.
You are for petitioner.
Yes, Your Lordship.
Item 26.
Yes, Your Lordship.
Sir, what is this? Other day I suggested them to have a amicable settlement.
I would be appearing in person in this case.
Okay.
There is a stay order also in the execution petition. So
Yes, that
just recommended. Let it be on Tuesday, next Tuesday.
Your Lordship, leading counsel is out of station because of some medical condition, Your Lordship. So, after 2 weeks.
No, that is too.
Your Lordship, there is not much serious about. We have already cleared all the.
Who is counsel?
V Jamo.
Huh?
V Jamo.
Yesterday he was here.
Yes.
Yes, sir. Today he went out out of station.
When is coming back?
Maybe after.
After a week or 2. After 10 days, let us see. If he comes back, it's okay. Not medical problem.
There will be next week.
Let us after 1 week.
Your Lordship, maybe on 2 weeks here.
So that it is unnecessary not listed. 10 days, make it 10 days. Hopefully he should recover by
Let it be on 23rd then.
23rd.
Okay.
23rd. Mr. So-and-so learned counsel appearing on behalf of Mr. B. Jemo, learned counsel to the petition. Appellant.
But we can observation that no more adjournment because
Mr. B. Jemo, learned counsel, learned living counsel is having a medical, is undergoing medical treatment for which he prays for 2 weeks time. Mr. T. Pratit Navid counsel appearing in person has vehemently opposed the prayer. However, in the interest of justice, let this matter be listed on 23rd.
Obliged, sir.
My lord, I beg to mention, item number 19, my lord.
19.
19, there are 4 matters in, 2 matters, that is IA 93 and 94. Service has been completed and the,
Let us see. Order.
I have to take fresh steps, my lord.
Ah.
In item number, in IA 95 and 96.
Item 9.
IA 95 and IA 96 of 2020.
Then item 9. Mr.
BK Singh, my lord.
BK Singh, Learned Counsel for the petitioner.
Petitioner, my lord.
Applicant. Some instance, he may be given 4 weeks time. 2 weeks time.
Within a week, I will take
He
time.
may be
We will,
take process steps
on respondent number 1.
for a submission not respond number 1. They are allowed. The Learned Counsel for the applicant is permitted to take process steps. Within 2 days.
Within 3 weeks.
Within a week.
Within a week, my lord.
Within a week.
My lord, and next date of posting may be on 21st of December,
This is matter of
31st of December.
21 of December, 21st.
21. This matter on 21/12/2023.
For, on behalf of government and police, he is also appearing, my lord.
Market.
My name, in item number 19 for the respondent.
First item.
Respondent number.
One.
Sole respondents.
He said,
No, sorry, respondent number 3.
You are respondent number 1.
Sorry.
you want to take steps for respondent number 2.
On 1, in the other 2 matter. In
He
9,
is appearing.
no, he is appearing in the 1
He
case.
will record his name.
He is appearing in 1, in IA number
93.
93, my lord.
93. He is
93.
appearing.
But I will take steps on 95, IA number 95 and IA number 96. There are 4 cases, my lord. tax
95
related.
and 90. Then you write 99. Then in 94 and 93 and 94, Mark is present. Mr. T. Patel, Learned Counsel. APS 4. Respondent number 1. And also, P. Public Government Council. APS 4 respondent number 2 and 3. 2 and 3.
Obliged.
Item number 16. I have just filed my wakalat number today. So even the petitioner is, counsel is not present. I may be given some time to file my affidavit. Item number 16.
Mr. T. Patel, Learned Counsel to the Learned Counsel. He has filed this forward on behalf of respondent, sole respondent,
Sole respondent.
for which he has person time to file affidavit,
Affidavit. 4 weeks.
public objection. Where is law, this method after 4 weeks, so as to enable this T. Patel to file appropriate affidavit.
Online.
Not appropriate, requisite affidavit. If you advise, correct?
May I, Lordship?
Yes,
Lordship, I beg to mention item number 25.
35.
Yes, Lordship. Lordship, I am for the petitioner.
25,
Yes, Lordship.
hearing,
Yes, Lordship. Lordship,
Yeah.
kindly, this matter may be fixed on 5th of December.
why? Others say, any objection?
No objection, madam.
Why it should be? Can it not be taken up today?
No, Lordship.
The Learned Counsel for the parties had identified that the matter may be listed on 5th of 5/12/2023. Where the this matter on Friday. Praise the Lord. And this the matter expected on 5/12/2023. Yes.
Obliged, Lordship. That's.
Your Lordship, I would like to mention item number 9. I'm for the petitioner. Your Lordship, it may be listed after 2 weeks. There is an interim order, that is stay of the proceeding, that may be continued.
9.
Yes, Your Absolutely.
On the prayer, your name?
VT Gurung.
Huh?
VT Gurung. VT Gurung.
Mr. Swain, the council. Hearing on behalf of this, the petition. Raised for a granted 3 weeks, 2 weeks. 2 weeks. This matter after 2 weeks.
Obligation.
May I, Your Lordship?
Yes.
Your Lordship, I have to mention item number 2 on behalf of leading counsel Elena Perman, Your Lordship. Your Lordship, I have taken consent from the other party also, Your Lordship.
On the prayer of the learned counsel to the petitioner, list this matter after 4 weeks.
After 3 weeks, Your Lordship.
After 3.
And Your Lordship, further she has requested to strike off the name of Bido Sora, Your Lordship, from the process.
You filed an application. No, it's okay. He has been.
He has been,
Appointed.
yes, Your Lordship, he is now JMFC.
The name of Mr. B. Sora, learned counsel, maybe strike off. The B is strike off. B is strike off.
Much obliged.
Your Lordship, I would like to mention that item number 20, maybe listed after 2 weeks. I have taken consent from the other side.
On the prayer of Mr. Swain, learned counsel, or prosecuted learned counsel to the petitioner. And don't be objected to by the respondent. This is matter. After 2 weeks.
2 weeks. Oh,
My lord, I beg to mention unlisted matter, bail application. This is urgent because medical ground. Bail
It's a
application.
Writ petition.
No, yeah.
What?
Bail application.
Bail application. Anticipatory bail.
No, bail medical.
Regular bail.
Yes. This may be.
439. 439. Tomorrow. Not today.
May I, Lordship, on behalf of leading counsel Mr. T. Tagum, I beg to mention item number 11 for filing affidavit in opposition, and item number 12 is analogous to the present matter. A long date may be given, Your Lordship.
You are for
Respondent,
respondent.
yeah, item number 11.
What's your name?
N. Kaki,
Mr. N. Kirky, learned counsel. Appearing on behalf of Mr. T. Tagum.
yes,
Learned counsel to the respondent. Submits the, he may be granted 4 weeks time to file appropriate affidavit. The prayers. Prayer is around. This is like after 4 weeks, so is the level the respondents will find contrary.
much obliged.
Lordship, may I beg to mention item number 20, supplementary. This 28, supplementary. This matter may be fixed after, yes. This matter may be fixed after 3 weeks. This case is represented by body-based lawyer, my friend lawyer.
Why this has to be listed? If it is for all mentioned.
That is why. They are supposed to come today, but they could not come. I have been requested to adjourn the matter after a 3 weeks.
Mr. On the prayer of Mr. T. Tapak, learned counsel for the appellate. This and prayer not being this matter after 4 weeks. 3 weeks.
3 weeks.
4 weeks.
4 weeks.
Mr. G. Tado, learned counsel to be learned additional PP present.
This matter is filed of application for this statutory ban. 439 read with section
It's NDPS. What is the mandatory?
Mandatory.
Your lordship, is the punishment is extended to 10 years, then it will be 60 as per Rakesh Kumar Paul case. Your lordship, by the majority of 2:1 ratio, your lordship, the Honorable Supreme Court has held that in the offences where minimum is 10 years and if it is death or life imprisonment or death, then 90 days, your lordship. If it is the minimum is not prescribed, your lordship, then in that case, and it is not minimum is not 10 years, then 60 days, your lordship. And even, your lordship, as per the NDPS case, NDPS Act, your lordship, the 180 days mandatory period, your lordship, that is pertains to certain sections, your lordship, not all the sections. Yes, your lordship, may 21B, the punishment is extended up to 10 years.
Extendable up. Extendable up to 10 years. That means punishment is below that. Only issue is that as per the mandate of the Constitution is here. There is two types of punishment. That is, one is 90 days, outer limit and 60 days. Another is 60 days. In the case of the punishment where it is extendable up to, extendable.
You have the Rakesh Paul.
Rakesh Kumar Paul.
I have both.
Which the paragraph?
Paragraph 12. Paragraph 30.
30.
Yes, sir.
30.
Certain before punish as per this, to my understanding, as per the provision of law, it should be the punishment, the offense which are punishable, punishment whose punishment is actionable up to 10 years. The minimum detention power is 6 years.
It's better 30 doesn't say anything.
30 then
33.
Yes, 33. And not less than 10 years, it is 90 days.
I know that. We know that. But then I want which since you are relying this.
Rakesh Kumar Paul.
When you were arrested,
I was arrested on it was
So
10 September.
you concede.
Yes, your lordship, we have to see whether charge sheet was filed or not. That has to be looked into because.
That's why I'm saying unless you concede.
Yes, your lord.
You take up the chapter.
Yes, your lordship. We'll take the status report, your lordship.
Where, from where? Which station?
Doimuk, your lordship.
Then tomorrow.
Tomorrow, yes, your lordship. Tomorrow we'll get this.
It has the right to, it's an indivisible right.
Yes, your lordship.
So 1 minute is also very, very precious.
Yes, your lordship.
Of course, it's NDPS.
Yes.
You just take the
Instruction, okay, your lordship.
Mr. Theta Bhagwan counsel for the this is an application for release of the accused person in connection with which PS case, Doimuk PS case under 50 of 2022 and section 21 within bracket small b NDPS Act, 1985. Very cool. Default pay. Release of equity. Just read that. This is an application for what? Just read that. Not religion. This is an application. Application filed by the applicant. Accused applicant. Accused applicant.
Accused is not applicant. Accused is inside the.
Why for the accused perhaps?
Is that
Release of the accused in connection with so and so, on default pay. This is Mr. P8 learned addition is directed to open instruction whether the judge is on by. I don't know that. Till the filing of this application.
So
You have filed it yesterday. Suppose if they file it today, even they will grant you. All right.
obliging.
At least this matter on 16 tomorrow.
Okay.
You can get it now.
Yeah, I will get the status. No issue.
Listen, what is this?
This is a regular second appeal matter. What happened
This to be done today.
Well, the notice need to.
I am not convinced with your substantive question of law, which you have.
Yes, my lord. My lord, my humble submission, my lord, my lord will find here in this page, my lord, there is the law, my lord, apparent law that substantive question of in second appeal, normally it is the substantive question of law only need to be looked into, my lord. Now, my lord will appreciate in this case.
I am not satisfied with the.
Yes, my lord. That I am.
Substantive questions you have read.
Yeah, yes, my lord.
The
That is my purpose. Ultimately, that need to be, my lord, frame under the supervision of this honorable court.
It should be hard also.
Yes,
to have that thing.
My lord, what my
What about the respondent?
notice needs to be go, my lord. Today is my lord.
Let us hear them also. Because to frame a substantive question.
Yes, my lord. Surely, my notice needs to be go, my lord. Ultimately, my lord, this is my proposal.
Have you taken the steps?
No, my lord, notice you have to be issued from this honorable court.
This is
my
this
lord.
is for the first time.
My lord, on the last occasion, my lord, this honorable court.
You have sought the adjournment.
No, my lord. Honorable court proposed not to issue notice, my lord.
Why?
I don't know, my lord. No, sure.
What? No notice was issued.
No notice was issued. My humble submission, my lord, in this case, my lord, there is a different finding, my lord, by the learned two court, my lord. My lord,
Okay, we'll go,
now that itself is a good ground, my lord, for to heart the matter by the reason in the second appeal, my lord.
So we'll hear the other party also.
My lord, in the meantime,
issue notice.
Notice, and my lord,
Unless we admit this, we may not.
my lord,
And we cannot admit unless we formulate the substantial question of law.
oh, my lord,
There cannot be admission.
my lord,
It is altogether a different thing. I think during the course of hearing, there may be additional questions, a substantive question, but then without admission, without formulating, we cannot admit this.
yes, my lord, that is true, my lord.
So we should notice only that will whatever your interim.
Ultimately, my lord, for framing substantial question of law, my lord, other side need to be had, my lord. Now, in between, suppose we say that, my lord, this honorable court view that, my lord, no interim order can be passed, my lord. Surely that is prejudice to the party, and that would be prejudice in a procedure, my lord. Therefore, I also try to find out whether, my lord, this honorable court, my lord, in such a situation, whether can pass 8 interim order, my lord. So this our division on division basis say, my lord, that can be, my lord. Ultimately, my lord,
You are the interim prayer today while issuing a notice.
my lord.
Huh? So that while we need to hear you.
Yes, my lord. My lord may hurt me, my lord. And this is my simple case, my lord. What happened in this case, in the I file a suit, my lord. I file a suit claiming compensation, my lord, for destruction of, my lord, demolition of my wall, my lord. That is simple issue, my lord. I file a suit claiming compensation for
What is the status of the land?
Land, my lord, is still in my possession, my lord. But after this order, my lord, they are trying to dispose me, my lord. That is specifically I have pleaded.
The ownership has been given to the respondent.
That finding was
Title.
no title was not
What
issue.
is the finding? What is the
Title was never issued before that. That is the other purpose in this order, my lord. Now, what my lord appellate court did, my lord, they somewhere, my lord, issued a decided title also, my lord.
What is that impugn or the judgment?
Impugn judgment, my lord, will find at page number 37, my lord. Start from, my lord, 30, my lord. Now, part specific para, my lord, page 46, my lord. 46, my lord. I am reading para 32, my lord. Page number 46. Last para, my lord. Up, page number 46. 46, my lord. After having carefully gone through the record, there is no issue to be determined by the collection of evidence. As all the fact of demolition, the fencing is admitted in the letter of the content of the same is very clear. I find no merit in the claim petition as discussed above. The plaintiff's respondent has no legal remedy being the land encroacher or committed trespass into land of the applicant without having any parcel and thereby creating nuisance to the peaceful possession of the applicant upon the unsold portion of land measuring 1900 square meter, my lord. Now, record speak otherwise, my lord. The material before the landed court below, my lord. Now, affiliate court, my lord, without, my lord, this was the title was never issued before the appellate court, my lord. Neither in the lower landed court below, my lord, the original court, my lord. Now,
You are claiming for compensation.
my lord, for demolition of my wall, my lord. That is, yes, my lord. The respondent, my lord, demolished my constructed wall, my lord. That is accepted, my lord. That I claim compensation for that, my lord. Now, trial court, my
You
lord.
are claiming compensation against what?
Demolition of wall, my lord. My wall. Boundary wall, my lord.
Your
Boundary wall, my lord.
boundary wall.
My lord.
Okay.
Now, that was the issue only, my lord. Whether they have demolished order, my lord. Now, landed trial court, original court found that yes, that was emitted by the respondent, my lord. Now, the title, my lord, was never a issue in the original court, my lord. The appellate court, my lord, from nowhere, my lord, record this finding. Now, by taking advantage of this finding, my lord, now they are trying to dispose me, my lord. So that's why, my lord, my humble submission, my lord, during the notice, my lord, at least, my lord, 8 interim, my lord, protection is required in this case, my lord. Now, my lord will see, my lord, basis of my lord, register sale deed, my lord. That also I have.
It's okay. Mr. Elton consulted. Issue notice to the respondent. So respondent.
3 respondent, my lord.
Issue notice to the respondents. Returning in 3 weeks. Before issue notice. That's so. This is regular second appeal by the appellant. Appellate judgment and decree dated 18/10/2022 was by the district judge.
This order needs to be estimated. Status quo, my lord. This is, my lord. If my lord allow me, my lord, I will. My lord, find out some purpose, my lord. That
till returnable judge. No, Having heard the learning concept on interim prayer.
No, yes, my lord. This is 1810 to 2023. 1810 to 2023. It's not proper, but my lord, I think it is proper, my lord. I have tried. Find out division base family is also there, my lord. Highly on this one.
Six and seven. None appears on hold. List this matter after 4 weeks.
Yes, your lordship.
There's nothing, any surviving cause here. It was section, proceeding under 133, CRPC. Yes, they stay.
Yes, your lordship. 6 and 7.
6 and 7.
Yes, your lord. Interim was already granted. Sir.
After 4 weeks.
Yes, your lord.
Non-abuse on call. Which was list after 4 weeks.
Oblige, your lordship.
Lordship, today we're supposed to produce CD, Lordship, but CD could not be produced because IA is on leave. So we have IO is this investigation of this matter. IO is on leave, Lordship. So I have got this information today, this morning.
So when do you want?
Lordship, I need some more time.
Non-abuse on behalf of the applicant. MS El Hage, learner additional people. Solicitors. She is yet to receive the case back. As the IO is on leave.
Lordship.
So in the investigation, he himself installed.
Lordship,
IO has installed the investigation himself. Very strange. List this matter after 2 weeks. If the petitioner is also not interested. And that to a regular bail. What's to be done?
Lordship, on last occasion they have not appeared. Perhaps they are appearing today itself. Lordship, now.
Who you are appearing for?
For a petitioner.
Who is for respond number 2? Non appears. Who is respond number 2?
Perhaps service.
Lordship, the service upon respondent 2 and 3 is not still awaited.
Only respond number.
Only respond.
Respond number 2 is only there, not 3, your lordship. In page number 2, your lordship, the petition post title. Yeah, 3 monthly. Yes.
Issue.
The criminal, your lordship, offense under IPC, your lordship, and it has been charge sheeted under section 363A.
Office note dated 14/11/23 next that service report upon respond number 2 still awaited. This matter after 3 weeks.
Oblige. Oblige.
Can we dismiss the criminal petition or criminal revision petition on default?
No, Your Lordship, without hearing on the merit, Your Lordship, recently the Honorable Supreme Court has that it cannot be,
I'm asking.
yes, it cannot be dismissed, Your Lordship, without considering the merit.
Non appears on call this matter after 6 weeks.
All right.
May I, my lord?
Yes.
The service report is still awaiting.
This administration, so ensure.
I may be allowed to take press steps.
Last steps on 23.
Hmm.
So you take press.
Yes.
Office note dated 14/11/23. Replace them. It's service report correspondent. Full response still awaiting. The done constitution permits to take press
The stay order may be continued.
on view of the fact that this steps were taken on 23/8/2022. Interim order passed earlier still continue. Yes,
Yes. Hopeless.
Well, Lordship, Lordship, my sincere apology that in item number 13 there was an interim, Lordship. In item number 13, there was an
13,
interim.
13.
Lordship.
1-3.
Lordship.
Is this right? You're, item 13. Interim order. Yes, item 17.
Item 17, Your Lordship. Your Lordship, we are appearing for respondent number 2. And we have already filed the wakalatnama today itself, Your Lordship.
So, what should be done?
Prayer for some time, Your Lordship.
It's the, what's your name?
E Paeng. E Paeng. E for eagle.
Elephant.
And yeah.
E Paeng.
E Paeng. Payen, Your Lordship.
Mr. E Paeng, member of council. Submitted. He has filed his power on behalf of respondent number 2.
Yes, Your Lordship.
For which he praised for some time. Mr. T. Additional here. Non-appearance for the petitioner.
Yes, Your Lordship, no appearance from petitioner side.
First you said non-appearance for the petitioner on call, then you write that, and then mark is present. List is better after 3 weeks.
Much obliged, Your Lordship.
Your Lordship, item number 13, there is a confusion, Your Lordship. I didn't find any interim order, Your Lordship.
Call him, check it out. We're yet to sign this thing.
Only said the prayer for interim shall be considered on the next date fix. But after that, there is no any interim order, Your Lordship.
Call him.
Okay.
Yes. Next. Non-appears on both MSL Hage present. List this method after 6 weeks. What is 21? 21. 21.
Lordship, this is quashing application. On the last occasion, Your Honor, my lord, CD has been called, and then in the CD there was no MLC. So subsequently, MLC has been called.
Yes.
May I please?
Just wait. What is the last one?
Last order. Last one. Okay. Your Lordship, MLC we have received. As per MLC, because injury is simple injury, Your Lordship. This is the case diary.
We'll see next week.
Yes, Your Lordship, next week.
Next week. We allow.
Oblige.
On the prayer of lunch council for the one, this next week, after a week.
Oblige.
Whatever 21.
Now only, Your Lordship, the 21 was done. 21 was done, Your Lordship. It was fixed on next week, 21, Your Lordship.
21.
21, yeah.
Yes. And then this is
22.
This is 21.
Yes, Your Lordship, 21. Where Your Lordship has passed the order, fixing a next date after a week.
Taxing Yari.
Yes, Your Lordship.
Item 21.
Yes, my brother appeared, Your Lordship.
Okay.
Yes, my lord.
22. Now 22.
Yes, Your Lordship.
Whatever 22.
Even this is a criminal petition, Your Lordship, on quashi settlement. Only is a very interesting issue, is Your Lordship. The accused has been charged sheeted under the section which is not applicable in Arunachal Pradesh, Your Lordship. State
What is
amendment
that section?
292A. This is state amendment of Odisha, not Arunachal Pradesh. However, they are approaching the courts squarely on the basis of settlement. Charge sheeted.
Hopefully, it's not charges has not been pressed.
Not framed yet.
Who is appearing for the petitioner? Item.
This case. Yeah. Here. This is joint application here on under 482. For quashing of the FIR, which was registered in Basar PH case number 1 of 2020 laws.
What is 292? A
292 lordship.
not applicable in state of state.
Yes, it's a Odisha, state of Odisha amendment, Your Lordship. Insertion for the state of Odisha.
We'll call for the IF or the OC, personal affairs.
But Your Lordship, this is squarely for on settlement. This is they have approaching on the basis of settlement between the parties. That can be done, Your Lordship.
Is it? Are you sure?
Yes, Your Lordship.
IPC.
IPC. 292 is there, but 292 capital A is not there. It's state amendment. Capital A making.
Is it not typographical mistake?
It
What
is.
is the charge sheet?
Charge sheet in page number, Your Lordship, 20, Your Lordship.
Is the IO
K Perme is the IO.
Still he is the IO.
Your Lordship, it's been culminated into charge sheet, Your Lord. Yes, he's remained the IO of this case, Your Lordship, throughout the trial.
No, in the same place.
The same place that has to be find out, Your Lordship.
Or Mr. K. Lawrence, petition. Two petition. How many petitions? Three petitions. Petition. And also
A1 जाना पड़ेगा.
course of the hearing. It is noticed that the charge sheet has been filed and section 292 being written. Capital N IPC 1860. IO. We noticed that section, I noticed the discord consisted section 292. It is written here, within the IPC. Correct.
Yes, State of Odisha, Your Lordship.
In view of the investigating officer of the Basel PS case number 01 Mr. K. Perme.
Yes, Your Lordship.
Is directed to appear before this court to explain. The another additional people shall communicate this order. I have is
Your Lordship.
It is not applicable.
Yes, Lord.
Or is it a typographical mistake?
Your Lordship, I didn't find typographical mistake because.
We'll find him out.
Yes, Your Lordship. Fixed date may be granted.
Monday.
Oh, Monday. Okay.
Directed to appear on Monday is what?
Monday is, Your Lordship, 20.
20.
20.
2023.
इतना जल्दी नहीं आ सकता.
Oh, tell it. This service may be in the jet.
Yes, Your Lordship. Oblige. Yes, Lord.
Lordship, my sincere apology, Lordship. Actually, I was mentioning, instead of 14, I was mentioning 13, Lordship.
Huh?
And that one. Instead of.
Your Lordship, where he has apprised this court that interim order is there. He's appeared in item number 13, Your Lordship. Transfer petition.
There was a mistake, Lordship. My sincere
No,
apology.
none appears in item number 14. Nobody appears.
Lordship. Lordship, not for the petitioner, Lordship.
You have appeared in item 14. Thai Siba.
Lordship.
Thai Siba.
Lordship. Actually, I was confusing. I forgot to bring their cause list. I was, instead of 14, I was mentioning on
Forget
13.
the cause list. Don't you have the brief when you are appearing for the petitioner?
Lordship, actually, I was confusing on 13. Instead of 14, I was mentioning.
We'll hear you today, item 14.
Lordship.
Do you have the brief?
Lordship,
you cannot afford to appear before this court without the brief. You decide. We'll see later. Item, you delete order in the item 14. Item 14, correct?
Lordship, 14.
We'll see later.
Now,
After some time.
now your lordship correction required in item number 13. Because
That item number 13 is no interim order. That's
your lordship, one more thing, your lordship. On last occasion also they have not appeared, your lordship. Subsequently, on this date also they are not there. Online.
That's why 6 weeks or 4 weeks.
Yes, yes. 4 weeks.
Next.
My lord, this one is also a criminal petition for quashing of the Jersey.
Your lordship, they have not taken steps. As per the office note. Yes.
Persistent.
Yes.
You take a step.
Yes.
Third Mr. D come with plan to the and also. The learned additional people for the state. Office note that 14/11/23 reflects that the learned council for the petitioner has not taken steps for service of notice of service of notice of responding. Mr. D come with learned council for the petitioner submits that he may be granted 3 days time to take steps. This matter after 3 weeks.
Deeply organized.
It is also quashing
Lordship.
section.
This one, Lordship, 279 304.
279
279 and 304. 279 and 304.
Your Honor, main counsel is not well, so tomorrow matter maybe.
Your name, please?
C. Peter.
Huh?
C. Peter.
C. Peter.
Peter.
Peter. Mr. C. Peter, learned counsel, appearing on behalf of
Tigame.
none of their this main counsel's name is there. You are for petitioner.
Yes, Your Honor.
Item 24.
Item 24.
We are dealing with item 24.
Yes, Your Honor. Item 24.
24 item. You said you are appearing for who is the leading counsel? Your senior.
Tazim Game. Tazim Game.
That's what I'm saying. It's Jayadoli, D. Yoka, B. Tagia, or Naji.
Lordship, they are from the same chamber. Their name has not been reflected.
But then somebody has to be, power has to be given to them. No?
Lordship.
It's okay.
Your Honor, matter may be fixed tomorrow. Matter may be fixed tomorrow.
No. What is to be done? It's on already stage.
They have come for the settlement, Lordship.
LCR not yet received.
LCR also not been received. LCR has also not been received. We call for the LCR.
We'll take after 2 weeks. Because LCR is here 2 weeks. Heard Mr. C. Peter, learned counsel for the petitioner. And also heard MS L. Hage, learned counsel, learned additional people for the state. Office note dated 14/11/2023 indicates that LCR is not yet received from the CDM procedure. List this matter after 3 weeks. The registry to send a reminder for LCR.
Like
What do you say? You have the brief now.
Lordship, in item number
When did
40,
you join the profession?
Lordship,
How many years you practice now?
it's been 2 years.
Huh?
It's been about 2 years.
2 years.
Lordship,
With whom?
Lordship,
With whom?
Mr. Npada,
Huh?
Mr. Npada, Nalapada,
And father.
Nalapada. Yeah,
Where
Lordship.
he is?
He is not present today.
We'll summon him. We'll summon your senior. What's your name?
JSRO, Lordship.
Huh?
JSRO,
Saro.
Lordship.
So don't appear in a case for the sake of appearing.
Lordship.
If you are asked by your senior, you just go through the brief, have at least the facts of the matter. You should maintain it. Not saying that you should not appear, you should appear to be proper. Make it a habit. At least know the facts.
Lordship, what is
If
the
you
next?
know the facts, then only you'll be able to say something.
Lordship.
Okay?
Lordship.
On the prayer of Mr. So-and-so, then consider this.
Lordship, may I?
List this matter after. When?
Actually, Lordship, if this matter is come to notice that the respondent parts, they have not contesting the matter actually.
Who?
From the respondent party on.
Who is the respondent?
Actually, notice has been served, but still.
Who is the respondent? Let us see.
It's been Lordship, three times we have taken the steps, but service upon one only this is completed and
No, that's why this has not been completed.
Lordship. And it was come to notice that the parties of the respondent parties, they have not contesting the matter.
No, ID card has yet to be received back. When did you take the step? You take press steps on
Lordship,
right.
31st. Lordship.
Office note, Mr. So-and-so and consequently today. Office note dated 14/11/2023 indicates that ID card in respect of respondent 2 and 3 is still awaited. The learning consequently petition is directed to take press steps for service of notice of respondent number 2 and 3 within 3 days. This after 4 weeks.
Lordship. Deeply obliged.
Then there is an interim.
Lordship.
Interim order plus earlier self-continuing.
Lordship.
What is this, madam?
Lordship, it was adjourned the day before yesterday.
Okay.
It's that matter. Lordship, I was allotted a quarter in the year 1997.
Yes.
Because of the dilapidated condition of the quarter, I actually made an application to the director housing also in 2003, saying that it has to be repaired, but there was no action. Thereafter, in 2004, near that quarter, I built a kacha house and I was staying there. Then in 2010, I built an RCC building without touching that quarter. But in the year 2019, that quarter collapsed. And now I'm being blamed for that, saying that I have dismantled that quarter. That is the case, Lordship. Now, Lordship, as per the one complaint was filed by one person who is not, he's actually a stranger to the case. He has filed a complaint and that complaint was forwarded to the estate officer, then thereafter to the director housing. Then thereafter, FIR was lodged and charge sheet was submitted against me. Now, if Lordship will see the statements recorded under 161 also, even the date of offense is not mentioned, and there is not even one single person who has any knowledge about this. They only know that the quarter has collapsed. And it is also a fact that that portion of the quarter which has been collapsed, that is vacant. I have not occupied it, Lordship. Now, Lordship, the sole ground on which I have been proceeded against is that I have not complained or I have not given information to the director housing that the quarter has collapsed. Now I'm no longer staying there, Lordship. So the only thing in my humble submission this case has is some suspicion of mens rea, but there is not a speck of actus reus, Lordship. So my question before this honorable court is, can the court proceed with only some suspicion of mens rea and no actus reus at all, Lordship? Now, in order to constitute a crime, both these elements have to be there, Lordship. This is the law, Lordship. Now, Lordship may see the annexures which I have appended, Lordship. The charge sheet is at page 18, Lordship. Charge sheet that is 14/9/2020. The facts of the case have started from page number 21. May I read, Lordship? The prosecution story of the case in brief is that on 21/6/2020, a written complaint was received from Sri Techi Gubin, Director Housing, Government of Arunachal Pradesh, to the CEO cum ADM, Capital Complex, to the effect that one quarter number 23/T1 located in Niti Vihar, Itanagar, and allotted to one Sri Tapak Natam was dismantled and a multi-story building was constructed by him. On receipt of the complaint, Itanagar PS case number 144/2020 under section 3 PDPP Act was registered and investigation taken up. During the investigation, complainant and witnesses acquainted with the facts and circumstances of the case were examined and other statements recorded. The photograph of the PO was taken and allotment order of the quarter number 2310 was collected. In further course of investigation on the basis of interim bail order passed by the Honorable Guwahati High Court, IPB, Naharlagan, alleged accused Tapak Natam was arrested on 4/7/2020 and released on PR bond with security as imposed by the court. Apparently, a notice under section 41A of CRPC was also issued to him for appearance before the court as and when called for. The investigation revealed that the quarter number 23T1 located in Niti Vihar, Itanagar was allotted to Sri Tapak Natam by order number dated 31/7/1997 by the Commissioner UD, Government of AP, Itanagar. However, in the month of March 2020, one Sri Navam Tama lodged a complaint before the Chief State Officer ICC that the state government quarter is dismantled. On receipt of the complaint, the CEO forwarded the same complaint to the Director Housing, Government of Arunachal Pradesh AP for inquiry by letter number this dated Itanagar, the 23rd March 2020. Subsequently, on receipt of the complaint letter, Sri Techi Gubin, Director Housing, inspected the area and found that one of the double unit of quarter number 23T1 located in Niti Vihar is demolished and doesn't exist at present. Subsequently, he lodged a complaint to the CEO for action, which was in turn later forwarded to OCPS Itanagar for cognizance. It is also revealed that quarter number 23T1 and quarter number 24T1 are double unit quarters which were allotted to Tapak Natam and Sri Tajam Natam respectively. The quarter number 23T1 was reportedly demolished in the year 2019, whereas quarter number 24T1 of the same still exists. The debris oblique remnants of the demolished quarter was already removed and used as an open space by Tapak Natam. Pertinent to be mentioned that one RCC building is constructed by Sri Tapak Natam in between the two quarters, that is 22T1 and quarter number 22T1 in the year 2010, and now he and his family are residing in the same building. It is also found that since the incident happened 1 year back, there is no direct eyewitness of the incident, but as a matter of fact, this quarter was allotted to Tapak Natam and it was his responsibility to keep proper repairing and maintenance with approval from the concerned authority. If the quarter was collapsed, then it was his duty to intimate the housing department about the incident, but Sri Tapak Natam didn't intimate. Rather, he completely removed the remnant of the government property without obtaining approval from the competent authority. It is worth mentioning that if one quarter was collapsed in rainy season, then how the second unit of the same block still exists, it inferred that he deliberately didn't inform the authority with malified intention to save himself from any legal complications that might have arose in due course of time. As such, it is evident that in the above facts and circumstances, there is prima facie case against the Tapak Natam, who has risen to demolish the quarter, being the allotee and the last occupant of the quarter. So therefore, I therefore beg to send the name of accused Tapak Natam to face trial before the court under section 3 of PDPP Act. The witnesses this lordship. Now, lordship, we'll see the statement of the witnesses, lordship. There are only 4 witnesses, lordship. The first witness is Techi Gubin, the director housing, page 28, lordship. 161.
Yes.
He says, I am Director Housing, Government of Arunachal Pradesh from the year 2005. I have lodged complaint against Tapak Natam, who is the allotee of Government Quarter number 23T1, located at Niti Vihar, Itanagar, and now dismantled. Actually, I was not aware of the incident, as inspection of Government Quarter couldn't be done in the last 15 years due to shortage of manpower. The matter came to light when Sri Talapotom, CEO, come ADM ICC, Itanagar forwarded a letter of complaint lodged by Sri Navam Tama to me. It was alleged that in the complaint that one Government Quarter 23T1 allotted to Sri Tapak Natam is dismantled. On receipt of the complaint letter, I visited the area, inspected the quarter line, and found one of the double unit Government Quarter 23T1 located in Niti Bihar has been completely demolished, and RCC building is also constructed in the same campus without any allotment order of land. I also found not a single part of the quarter 23T1 exists, and area is clean now. On the other hand, the second unit of the same block, that is quarter number 24T1, still exists and occupied by Sri Tajum Natam. The allotee of the said quarter, namely Tapak Natam, didn't inform the office about the said matter. Later, he removed and disposed of the government property without any authority. Subsequently, I lodged a complaint to the Chief Estate Officer, come ADM ICC Itanagar for action, which in turn forwarded to OC Itanagar PS for cognizance. Next is Lordship Navam Tama. This is the alleged complainant, Lordship. He says, I am as above, I am a businessman. I have been residing near the Government Quarter 23T1 located at Driver Colony, Niti Vihar, Itanagar. In the month of April 2020, I noticed one Government Quarter is totally dismantled and one multi-story RCC building has been constructed by the allotee of the quarter, namely Sri Tapak Natam, in the same campus. Nowadays, there is rampant encroachment of government property, so I decided to intimate Sri Talapotam, Chief Estate Officer, come ATM Capital Complex, with a view to take action against the erring person. Now, Lordship may notice one thing.
Public spirited person.
I will show from the records he is a private spirited person. Now, Lordship will see. He says in the second line, Lordship, of his statement, in the month of April 2020, I noticed one government quarter is totally dismantled. But from the records, it is seen that his complaint was made in the month of March 2020, not in the month of April. This is something your Lordship may notice. I'm coming back to the letter on, Lordship. From the FIR also, copy of the FIR also, Lordship will see the complaint itself is dated 16 June 2020, but it has been mentioned that the complaint has been received in the month of March 2020. This is page 35, Lordship. This is the letter which the Director Housing had given to the Chief Estate Officer, saying that complaint against demolition of government quarter dated number 23T1 Niti Vihar. Reference your letter dated this dated 23/3/2020. On receiving your forwarding letter of complaint against one Tapak Natam for illegally dismantling quarter number this at Niti Vihar, and undersigned inspected the area and found Tapak Natam peon, AP Secretariat, and allotee of the quarter in question has demolished one of the double units of the quarter and constructed a multi-story building. In view of the same, it is requested to kindly book the culprit and initiate action against him. Now, what happened is, Lordship, Navam Tama made a complaint to the Chief Estate Officer. On receipt of that complaint, a letter was forwarded to the Director Housing, which is dated 23/3/2020, which is mentioned in this letter. Thereafter, Lordship, again, on the basing on this, formal complaint has been made. Basing on this complaint, the FIR has been lodged, Lordship. So it is clear that that he's saying that he noticed that the government quarter was dismantled in the month of April, that itself is wrong, Lordship. Now, Lordship, we'll see page 30. This is Tajum Natam, the person to whom the adjacent quarter was allotted, Lordship. I am as above, I am working page 30, Lordship, 30.
30.
Yes. This is one of the witnesses. I am as above, I am working as a chokidar, watchman at OPD trims under Health Department, Government of Arunachal Pradesh since last 18 years.
Your brothers or what?
We are not real brothers.
Cousin brothers?
No, same clan, actually. I am the neighbor of Sri Tapak Natham, an occupant of quarter number 23T. This is adjacent to that alleged demolished quarter, located at Driver Colony. The said quarter was allotted to me in the year 2012 by the Housing Department. The quarter number 23T1 was allotted to Tapak Natham, occupied by him up to last year, that is 2019. However, in the last year, I came to know that the government quarter was collapsed in the rainy season, but I can't say more details nowadays as I have been residing at Cochin Colony, Naharlagan, due to some domestic problem.
That's why.
Lordship?
Purposefully, I asked you whether he's your brother or
but that is not the reason that he's giving this statement, Lordship. That is not the reason. I have annexed the photographs of that quarter also, Lordship. Out of
he said it was collapsed.
Collapse, yes.
By itself.
Yes.
Rainy season.
Yes. It is a fact that my quarter still exists and occupied by me, which is second unit of the same block, Lordship. Even that quarter is, I have personally visited it, Lordship. It's on the verge of collapse. Nowadays, people have to hold the quarter together like this. Yes. Otherwise, it's a fact, Lordship. Now, page 31, Lordship. Sadhu Charan. This is also one of the persons residing in the nearby quarter. 22, 23, and 24. This is this is the person residing in 22. I am as above.
In between 23 and
24.
And 24.
Yes.
It's vanished.
Yes.
How is vanished, we'll see.
I am as above. I am working as a driver under Social Welfare Board. I have been allotted 22 T1 and neighbor of Tapak Natham. I have been residing in the quarter from March 1986. It is a fact that one RCC building was constructed by Tapak Natham in between 22 and 23. The said building was constructed 7-8 years back, and I have no idea about its legality. It is also a fact that quarter number 23 was occupied by Tapak Natham, which was collapsed in the year 2019. However, I can say whether it was collapsed or dismantled intentionally by anyone, as it is covered by RCC building surrounded by RCC boundary wall. But it is true that the area of the quarter is clean and vacant now. The next is, Lordship, the statement of the accused person himself. Page 32. I am, as above, I'm working as a peon and presently posted in Home Department, Civil Secretariat. I was allotted one government quarter, dated quarter number 23, located at Drivers Colony in the year 1997. The quarter is outdated in dilapidated condition. I had requested several times to the Housing Department for repairing and maintenance, but in vain, and ultimately in the year 2019, the quarter collapsed in the rainy season. It is a fact that the RCC building constructed between 22 and 23 belongs to my wife. However, it is true that it is not true that I have dismantled the government quarter of construction, which was for construction of this building, which was actually built in the year 2010. The said building is constructed prior to the incident. Process of allotment of the said land is under process. It is also a fact that I didn't inform the Housing Department about collapse of government quarter. Rather, I removed the debris in the demolished quarter and got on good faith. It is also a fact that I didn't make correspondence to the Housing Department for repairing and maintenance in writing. Rather, it was reported verbally. Now, Lordship knows that this is a statement under 161. Actually, I had submitted a document to the police regarding this, Lordship, but that document was not reflected in the charge sheet. And they have said that I have not, in fact, it is written that I have not made any, representation in writing, Lordship. But that is not true. I had given to the police, but they did not enclose this. The problem with this kind of situation is there will be facts supporting the accused. There will be facts indicting the accused. Now the police is under a duty to bring all those facts together, Lordship. They don't do that, Lordship. This is what happened, Lordship. So therefore, during filing of the search petition before the Honorable Trial Court, I submitted this, but order was not given in my favor, Lordship. So, Lordship, that is at page 52, Lordship. That representation, Lordship. I have made way back in 2003, Lordship. Page 52, Lordship. This is the type copy, but it is actually handwritten. Since I'm working as a peon and I'm not very educated, this was written on my behalf by someone else, Lordship. Here I simply said that I have been allotted the quarter in 97 as aware the civic amenities which the employee gets is nil, necessary item, table, chair, and etc. are also not there. When occupy the quarter, such as electricity, water connection, pipe, all are dismantled and torn. Therefore, I want repair so that human life is at risk while staying in the quarter. This is what I stated, Lordship. This, Lordship, will see in the next page. It was received also, Lordship, but it's not very visible now. Page 54 is the photograph which I had annexed at that point of time.
Received by whom?
Received by the office of the director, Lordship.
Okay.
Now, Lordship, will see in page 54. In 2003, the picture of the quarter was like this, Lordship. They didn't do anything, of course, after this also. Verbally, too, I have met many times. So, Lordship, this is the case, Lordship. Now, Lordship, let us come back to the public-spirited person, Lordship. What happened is, Lordship, this person, Navam Tama, he wanted to occupy the quarter, which is quarter number 22, Lordship. Quarter number 22, your Lordship will recall, which is at present allotted to one Sadhu Charan. So that Sadhu Charan is about to retire, Lordship. Now he wanted to occupy that. Therefore, he was trying to drive them out actually, so that he can occupy that. But I, being a good neighbor, I had intervened, and because of that, he has a bad blood with me. Now, Lordship, regarding that, Lordship, it was later on that quarter was, even before Sadhu Charan's retirement, it was allotted to the wife of Navam Tama, and it was not allotted to wife of Navam Tama, it was allotted to Biki Yapa, Lordship, and that was challenged by Navam Tama's wife. That also, an order also I have annexed at page 62, Lordship, of Honorable Court's order. That was dismissed, Lordship. Now, Lordship, because of this, Lordship, this Biki Tama also happens to be my relative, Lordship. So there is a bad blood between us. That is why, Lordship, he has made this complaint, Lordship. Now, he himself is interested in that quarter number 22, Lordship. Maybe he feels that if he enters that, then there won't be enough space, or whatever is his reason, Lordship. That is also one of the reasons why I filed that research application, Lordship. Now, leaving that apart, Lordship, even if we go simply by the records of the charge sheet, Lordship, then also, Lordship, except there is no one who says that I have dismantled the quarter, Lordship. They have only the director housing. He has himself admitted for the last 15 years there is no maintenance at all. He does not know anything about it. The complaint which is emanated from Navam Tama only. Navam Tama also does not have a personal knowledge. In fact, he himself, after making complaint in the March 2020, he says in April 2020, I saw that the quarter was dismantled, Lordship. Then, Lordship, we'll see only on suspicion this, Lordship, although it is true that I have been negligent in not giving the information to the authorities, but can that make me liable for an offense under Section 3 PDPP, Lordship? That is the question Lordship will have to see, Lordship. Now, Lordship, if in any case, Lordship, according to the statement of the witnesses, it seems very unclear as to when the date of offense is, Lordship. So some are saying 2020, some are saying 2019, Lordship. That is also not clear, Lordship. Now, Lordship, we'll see the charge sheet, Lordship. Oh, sorry, the impugn order, Lordship. Charges and the impugn order, page 36, Lordship. Page 36 is the charge frame against me, Lordship. Firstly, quarter number 23 T1 Niti Vihar was allotted to you in the year 1997, and you demolished the said quarter and constructed your private residence RCC building in nearby compound of the said quarter in the year 2010, Lordship, and thereby committed an offense under Section 3 PDPP. Now, when you read the charges frame, it appears as if I have demolished the quarter in the year 2010 and have built an RCC building, Lordship. Here also, Lordship, this is in fact factually untrue, Lordship. The RCC building that was constructed in the year 2010, Lordship, the quarter is said to have demolished or collapsed in the year 2019, Lordship. So basing on this, I don't know how the trial court is thinking of proceeding, Lordship. So the charges itself is factually wrong, Lordship. I have also enclosed the allotment copy of copy of my application for allotment. This is page 52, Lordship. Sorry, not page 52, Lordship. Page 55 onwards, Lordship.
Why you are interested in the church? Why don't you go for equity? These are the, I think, method to be.
Lordship, I'm a peon, Lordship. I can hardly afford, Lordship. In fact, this person is.
No, that is something no one can help with.
Yes, Lordship, but
these are not the things, the way you have projected.
Yes.
These are the grounds you may not be, you will not be convicted. But
Lordship,
at the time of framing of charges, you know that you're well aware.
Yes.
It's not that it's only the private residence.
Yes. Lordship, criminal trial, Lordship, calls for strict liability, Lordship. Now, Lordship, in order to, I'm not saying, Lordship, that there should be nothing, absolutely nothing against the accused person. I'm not saying that, Lordship. What I'm saying is, Lordship, that there has to be something against the accused person, Lordship. Now, Lordship has seen the records, Lordship. Other than a mere suspicion, is there anything else? One line, Lordship, saying that.
That is a good ground.
No, that is a good ground for research, Lordship. There is a good ground for acquittal would be if there is something, but they are unable to prove it.
Yeah.
This is a situation in which there is nothing, Lordship. It is a fact, it is a settled law that actus reus and.
See, the learned TGM has said.
Yes.
In your 161 statement.
Yes.
Nowhere you have said that you have informed the concerned authority.
Yes.
When it is likely to be or
danger
of collapsing.
Yes.
That's the reason, and the quarter was allotted to you 97.
Yes.
Till it vanished on the air.
Yes.
In the air. So that kind of you may say so that it's just mere suspicion.
Yes. No, suppose that quarter has collapsed.
Yes.
Suppose I say that quarter has collapsed.
Yes.
Suppose my building is built on that land. Suppose. Then also I would say that suspicion is good enough. In this case, that place is vacant.
Okay.
Yes. That building which I have built is nearby that quarter, but that place itself is vacant. The witnesses also have also stated that.
Have you not taken something because your wife has already constructed a RCC store down the multi-story building?
Not multi-story, it's just.
Some areas you might have enforced.
No, Lordship. It is still vacant, Lordship.
See, this is the building.
Yes.
Area of the building. You cannot, that open portion.
Yes.
You might have enforced it.
No, Lordship. Even a wall is not being built there, Lordship.
Otherwise, how can you construct a multi-story building in between these two quarters?
That building is really small, Lordship. It is not. I mean, if we had
They said multi-story.
multi-story, they're saying multi-story, but it is not actually. So only one floor house, and it's a very small one. But Lordship, regarding Lordship,
Okay, actually it's okay.
Yes.
I've understood.
Regarding Lordship,
Go to the law.
yes.
What are the laws?
My first ground is Lordship.
Yes.
I'm relying on 2021 SSC online. 2021. We don't have available नहीं है. मेरा इसमें. This is the first case I'm relying on. This is para 16, 17, 18, and 19. More particularly, para 17, last page, Lordship.
17.
Yes. Further, it is well settled that the trial court, where considering the discharge application, is not to act as a mere post office. The court has to sift through the evidence in order to find out whether there are sufficient grounds to try the suspect. In order to find out whether there are sufficient grounds to try the suspect, the court has to consider the broad probabilities, total effect of evidence, and documents produced, and the basic informatives appearing in the case, and so on. The court, likewise, the court has sufficient discretion to order further investigation in appropriate case if need be. Also, Lordship, paragraph 16, Lordship, the correct position of the law laid down in Madhuli Maya is that order framing charges or refusing to charge are neither interlocutory or final in nature and are therefore not affected by the bar of section 371. That apart, this court in the above citations unequivocally acknowledges that the High Court is imbued in inherent jurisdiction to prevent abuse of process of court and to secure ends of justice, having regard to the facts and circumstances of a case. As a caveat, it may be stated the High Court, while exercising its aforesaid jurisdiction, ought to be circumspect. The jurisdiction vested in the High Court is to be invoked carefully and judiciously for effective and timely administration of criminal justice. The court does not recommend a complete hands-off approach, albeit there should be interference, maybe in exceptional cases, following which there is a likely of serious prejudice to the rights of citizens. For example, when there is their contents of complaint or other person purported material on record is a brazen attempt to prosecute an innocent person, it becomes imperative upon the court to prevent abuse of process of court. When the accused is praying for a discharge, when the accused is praying for a discharge, it is his available right, Lordship. He cannot be asked to simply wait for acquittal, Lordship, even if there are no prima facie cases, Lordship. The court is not to simply say that, okay, there are materials against you, you have to be tried, Lordship. Court is to see whether those materials are enough to try the accused, Lordship.
What is let us see the NDPS.
Prevention of damage to public property.
Section
3. any mischief. Yes. Yes. Second one, Lordship.
This is.
I am saying the court has to sift through the evidence
Hmm.
and see whether it can proceed or not. Because the right of the accused for a discharge is also available, right, Lordship. Just because there are some suspicion does not mean the trial has to proceed, Lordship. Court must make up its mind, Lordship. Then, Lordship, 1960 Criminal Law Journal 393.
390?
393.
393.
Yes. Paragraph 26, Lordship. Of course, this is a case in which the question was whether or not the alleged offense was attempted offense or actual offense. But what I'm trying to rely on is paragraph 26, Lordship. Paragraph 26.
Yes.
This is the Punjab Haryana High Court. Paragraph 26. The offense which is constituted by the concurrence of mens rea followed by an actus reus, both elements of the crime must coexist, and the proof of guilty intention without the overt act of the deed not shown to have been actuated by any criminal intent cannot result in conviction. Prosecution has to establish both elements of the crime by proving that the accused did something which in point of law would be the intention of the commission of an offense, and that in taking that step he was inspired by an intention to achieve the definite objective which constituted in the particular crime. The actual steps may manifest in the guilty intention in furtherance of which he had proceeded. Now, Lordship, it need not be repeated. It is the basic thing in law that two elements have to be there, Lordship. The one part of the element is not even suggested, Lordship. How can the court proceed like this, Lordship? Now, regarding that, that I have not made any complaint or against that, Lordship, earlier, Lordship. That, Lordship, I had already met, I had already given, Lordship, some materials to show that in 2003 only I have given that complaint to the Director Housing, which was not acted upon, Lordship. Now, of course, the court may not look into materials outside the charge sheet, Lordship.
Say that thing in your 161.
Yes, I have not said that, Lord.
You said only
No,
verbally.
That is what I'm saying. I submitted this before the police. They did not record it, Lordship. Now, 161 statement is not something that which is read over to us and actually we have signed it, Lordship. It is not like that, Lordship. My specific contention was I had given that letter, but that was not reflected. Instead, it was written that I have not made any written complaint, Lordship, but which is not true, Lordship. So therefore, in the discharge application also, I had enclosed this and I had given a specific statement, Lordship. But, Lordship, that was not considered, Lordship. Now, Lordship, in criminal cases, it is, although it is true that materials outside the charge sheet may not be considered, but it is not an absolute thing, Lordship. The Honorable Supreme Court in 2008, Volume 14, SCC 1, 2008, Volume 14, SCC 1, Para 22.
SCC 1.
Yes. 2008, Volume 14, SCC 1.
22.
Yes. Actually, it starts from Para 20. A submission was made that only the materials which was placed by the prosecution side can be looked by the court. Rebutting that submission, the Honorable Supreme Court has said in para 20, 21 and 22, may I read 22, Lordship, para 22, starts from para 20, in fact. Thus, in our opinion, while it is true that ordinarily defense material cannot be looked into where framing charge in view of the DN party's case, there may be some rare and exceptional cases where some defense material, when shown to the trial court, would convincingly demonstrate that the prosecution version is absolutely totally absurd and preposterous. And in such very rare cases, the defense material can be looked into by the court at the time of framing charges or taking cognizance. In our opinion, therefore, it cannot be said as an absolute proposition that under no circumstance can the court look into the material produced by the defense at the time of framing charges. Though this should be done in very rare cases where the defense produces a material which convincingly demonstrates the whole prosecution case is totally absurd and totally concocted. Now, Lordship, for this point also, I'm also again relying on 2018 Volume 2 SCC, 2018 Volume 2 SCC, page 93. Here in this case, 2018 Volume 2 SCC, page 93, paragraph 8. In this case, there was a prayer for summoning some documents which would have been of help to the accused side. In that situation, although the Honorable Court held that it's not possible, but still held that it is clear that where ordinarily the court has to proceed on the basis of materials produced with the charge sheet for dealing with issue of charge. But if the court is satisfied, there is a material of sterling quality which has been withheld by the prosecutor, investigator, prosecutor, the court is not debarred from summoning or relying upon the same, even if the document is not part of the charge sheet. It does not mean that the defense has the right to invoke Section 91, the horse satisfaction of court at the stage. So, Lordship, I have placed these materials which was not considered, Lordship. Now, Lordship has seen the charge sheet also. That is, Lordship, factually also wrong. It has been made to, I have been charged saying that I have built, I have demolished the quarter and built my building in 2010, Lordship. It is even contrary to the charge sheet, Lordship. Now, how can the court proceed on this, Lordship? Now, Lordship may say that I can go for the trial, I can, wait for the acquittal and all, Lordship. But, Lordship, when there is nothing, absolutely nothing in a case to proceed, why waste the time of the court? Why waste the time of the public? And why waste anybody's time and money, Lordship? Especially money, Lordship. Because,
according to you?
Yes, Lordship.
What is it according to the law?
According to the law, Lordship, the reason why this charge is given is because proceeding on a case which has no basis or which has no material will only result in...
What is this page 63?
Page 63, Lordship?
Judgment of this court.
This is the judgment of the complainant's wife with my neighbor, Lordship. They are trying to take the quarter number 22, and because of that, they were fighting, Lordship. And that is why I've been, Lordship, since I'm also a relative of this person, Lordship. Otherwise, Lordship, every day.
Just a reference.
Yes.
So,
Lordship will also see.
Something behind the complaint.
Yes. Lordship will also see page 75 onwards, Lordship. These are the photographs of my adjacent quarter, Lordship. This is the situation here, Lordship. They are somehow holding it together, Lordship. And Lordship, there are so many quarters which are being demolished, so many quarters which are being, where is this Nagam Tama?
There is something which you...
Yeah, Lordship. So I have placed this also, Lordship.
That's all.
Yes.
Yes, madam.
Lordship.
What is the prima facie view? I mean, that can say that judge can be framed.
Lordship, because Lordship, this,
Just because you use the word prima facie. it's
Lordship,
not-
the prima facie case was established by the session court Lordship, as CGM court Lordship, sorry. After go to the charge sheet Lordship. In
That's
charge
it, nothing.
Lordship, the charge sheet Lordship, it is there Lordship, because Lordship, maybe there is no direct eyewitness Lordship. As all the witnesses statement was there.
Two witnesses said so it has been, it's collapsed during the rainy season.
Lordship, that was the Lordship, it is Lordship.
Nobody has said-
It's kind of unbelievable because during rainy season, okay, Lordship, it can be Lordship. But how can Lordship the same block 2 unit Lordship? That rain got only shower the blessing of the 1 minute only.
Being maintained by the occupants. So
Lordship,
he's not staying there now, no more. He has constructed his own building.
Lordship, that's why Lordship, now it is something Lordship, that's why there's Lordship, CGM court
No,
may have.
there's nothing to show that it has been banished.
Lordship,
What-
because
what
Lordship,
I'm trying to say that suppose you construct a building by demolishing that. That is, it appears to be like that. But there's nothing on record to show that that is the case.
Lordship,
This
they
is-
have never approached the department also, Lordship, for the maintenance.
2003 he has approached. There is receipt, there's a receipt.
Lordship, 2003 is, Lordship, but we,
Of course, he never mentioned his 161 statement.
Lordship,
He said verbally.
this is their Lordship.
The peon, he may tend to he may forget.
Because record is not also their Lordship regarding their approaching Lordship letter is also not there in record also. I cannot say that it is manufacturer because maybe it's manufacturer one because there nothing in record at all Lordship. Regarding that statement also Lordship, one this witness is maybe his cousin also because the same title is there Lordship, and another one also he's also
Unless it is so by the reports or whatever, you just cannot presume.
But
And then in a lighter vein only I ask her.
But-
Because next, before he.
And they are living in
the. Read out the 161, I mean that other person. The 24.
23, 24, that's it.
The driver or something.
Yes.
I read it that yes, it has collapsed during rainy season. When I noticed that, then I asked
Well,
whether
kind
he's your brother or cousin or something like that.
Lordship,
That is something out of
Lordship. This was a proper Lordship trial, maybe Lordship required Lordship
He's
because
saying those who have said, I mean the other one, 24, who occupied this allotted button number 24. He must be a cousin or a
No, sir.
brother or something.
But there is also another witness, 22 who say the same thing.
Lordship, there are other witnesses also. They are not all. They are Lordship. You go to the other witness once
No,
again.
it's okay. According to you, there is a prima facie case.
Lordship, it is yes, Lordship. They have every opportunity given before the CGM court also, Lordship. After hearing both the
any other law, because he has relied 4 cases or 5 cases.
Lordship, as per this, if it's already primary case established, Lordship, then I'll go to this section only, Lordship, because already established before the Lordship CGM court.
No,
Lordship.
that's established according to prima facie of the CGM.
No.
That is put to challenge now before the High Court. So on the materials of the material, you can show us.
Lordship,
Anything to be shown.
Lordship, Lordship, I have Lordship now, so I have no.
Give me some them. You read this court judgment.
Lordship, then
I'll not hear her. I'll
Lordship.
hear you tomorrow.
Lordship.
You go through whatever there may be
Lordship.
other cases which may support you.
Mhm.
Supreme Court, High Court, whatever.
Mhm.
All right.
Lordship.
We'll keep it pardon.
But Lordship, anything,
But
Lordship,
I would like to submit that everything emanates and everything comes from the record. If the record is not there, the Supreme Court cannot come and
anything, Lordship,
No,
order.
that's what I'm saying. That's what I'm saying. Unless you want to show from the records. The records is what? The statements and any documents in the church sheet. Huh?
Lordship, LCR is there, Lordship.
How then I'll see. But then it's your submission. You can use this elsewhere also.
Lordship, because
I have annexed practically
if-
everything.
then if possible, I'll go for the CD also, or also Lordship.
This is a court record if you want to
No,
look
sir.
into
It is-
receiving additional PP. We'll provide this. You can look into it. All right.
Yeah.
And any other case laws you may, we'll take up tomorrow.
Lordship.
Or at 2.
But tomorrow,
I
Lordship.
just
because-
want to complete this.
Lordship.
At 2, Lordship.
Yours,
Yes.
your part is over.
Yes.
Because I think she.
No, I'm afraid of her.
She
Long
because it's-
If she brings us some other weapon, which I'm
No,
not
no,
aware of.
that you, I will allow you to rebut whatever.
Yes.
Reply to that.
Yes,
Let's not be one-sided.
yes.
Now today I've heard you. I'll hear her tomorrow. And if anything you have to reply. tell me. But that will be taken up as a last item.
Tomorrow?
Tomorrow.
Okay.
Heard. MS did, and then this constituted petition also. MS. Hearing remains inconclusive. Listing matters tomorrow. Even if any which is listed, any item.
Then item number 6 and 7 would not be present when the matter was called up. There was an interim that was existing at that point in time. So interim may be considered. My deepest apologies, sir. We could not reach here on time at that point.
You should be on time for this. If item 6 and 7, check out. Interim order.
Idea by Shri.